So what is nuisance and how has the law changed? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel. So David Smith is a partner within JMW's property litigation team. You may have seen on the news about a recent case involving the Tate Modern. So David, what's happened in that case?
Well, it's been a long-running saga. It's been through the High Court and the Court of Appeal, and in both occasions, the Tate actually won. It's got the Supreme Court, and the Tate has definitively lost the case. It's taken the Supreme Court a hell of a long time to produce the judgment, over a year, which is a bit odd because they actually say in the judgment that it's a very simple case. So I'm not quite clear why, if it's so simple, why it's taken them so long. But the summary of the position is that the use being made of the what's called the Blavatnik building and its viewing gallery, which is what was being complained about by the Tate Modern, is a nuisance, and it's going to have to stop.
And does that mean then in the future people need to be careful what they build and where they build it?
Not really, not for most cases. So the Supreme Court actually takes us on a bit of a tour of nuisance law, way back into the history of nuisance, and restates core principles of nuisance. So things that people often moan about nuisances they remind us aren't relevant. The fact, for example, that a nuisance already exists if someone is using a property in a way, and I come to that nuisance by moving in next door, is not a defense to nuisance. If I build my property or construct my own property in such a way as to make the nuisance worse for me, that's irrelevant as well. So one of the arguments that the Tate said, hang on a minute, this neo-Bankside place, they've got these gigantic picture windows. If they put small, neat, discrete windows that people couldn't peer on, it wouldn't be a problem. And the Supreme Court says nothing to do with it. The issue is whether the use of the land that's alleged to cause the nuisance is a reasonable, normal use of the land. Now, people got themselves very confused in terms of reasonableness, and that's not what's happening here. It's not about whether I'm doing it in a reasonable way. It's whether it's a natural, normal use of land, or alternative is a slightly exceptional or unusual use of the land. And the reality is that placing a viewing gallery on your property, which has millions of visitors, and is one of maybe 2 viewing galleries on the south bank of the river, is an unusual use of land. There's no two ways about it. And the alternative point that was posited by the Supreme Court is if they hadn't built the Blavatnik building and a viewing gallery, and had just built a block of flats, all of which happened to have picture windows that looked into the neo-Bankside picture windows, that would be fine, because that is a normal use of the land. But it's the building of the viewing gallery, which has nothing to do with the Tate Modern's primary purpose as an art gallery. It's meant to be there for people to look at art, not to go and stand on balconies looking at the world around you, although I suppose they would probably say that the world is art. It's that unusual use that makes it problematic. So from a developer's perspective, if what they're doing is building flats and carrying out ordinary development to use land in normal and expected ways, that's absolutely fine. If they want to do something unusual, and I think that the case that's going to be quite interesting off the back of this is there's a big development in East London, in Stratford, where someone's proposing to cover a building in lights, which is going to show pictures and advertising up to 11 o'clock at night. And I would have thought they'll be looking carefully at this decision and wondering whether that's actually something they're going to be able to do.
And how can you and the property litigation team help anybody who's concerned about nuisance? Of course, it doesn't have to be a museum with a viewing gallery.
Well, yeah, I mean, the vast majority of nuisances have nothing to do with large art galleries on the south bank of the River Thames, and very few of them end up in the Supreme Court. So nuisance can occur in all circumstances and anywhere where there's people interacting through property. So we're obviously well versed in the most recent decisions, and are happy to assist people and explain to them whether their problem is falls within the law of nuisance and what they can do about it.
David, thank you very much for your insight. And if you'd like to contact David, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for all the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.